On behalf of Dr. Juan Oliveras, I would like to welcome you to our campus here, and I hope you're comfortable and you got something to drink, and we're going to get on with the program. I would like to introduce our moderator, Valerie Pierre Simmons. Valerie is a partner in Warner, Norcross, and Judd. She is the chair of the Warner, Norcross, and Judd Education Law Group. She is a litigator, and her primary area is health and education law. She has been the recipient of several awards. I'll just name a few. She was the recipient of the 2002 Distinguished Community Trustee Award by Leadership Grand Rapids. She has been the recipient of the Floyd Skinner Justice Award in January of 2002. She has also been the recipient of the State Bar of Michigan 1993 Outstanding Young Lawyer Award. She has numerous community affiliations, and just to name a few, the Civil Rights Commission, Michigan Civil Rights Commission, Grand Rapids Service Corps, and Grand Valley State University Foundation Board of Trustees. It is an honor for me to introduce to some and present to others Attorney Valerie Pierre Simmons.
So, just let me say thank you and welcome. I am really pleased and honored to be moderating this discussion this afternoon around the Michigan Civil Rights Initiative. I come to this issue by a tortuous path. As an African American, in particular as an African American lawyer, I've always had a strong interest in civil rights. Over the past 7-8 years, I have served on the Michigan Civil Rights Commission, and in my last year on the commission, I served as its chair. During my tenure on the commission, this particular issue came to the fore. There are few issues in American history that have raised as much controversy as this and similar initiatives around the country. And it started approximately 42 years ago with an executive resolution from President Lyndon B. Johnson. Now, President Johnson, one of my heroes, actually, although he came to his hero status again in a tortuous past. But when he became president of the United States following the assassination of Kennedy, he inherited what could fairly be described as a mess. The civil rights movement, led by Dr. King and others, was just in its early stages. Congress had been battling against strong opposition from Southern representatives and senators to find some sort of civil rights legislation that would enable the country to move forward on the issue. Johnson was from Texas, not far from where I grew up, and he had lived firsthand discrimination in all of its various forms. And he recognized very early on that simply passing a law that says thou shalt not discriminate really wasn't going to take care of the issue. He also realized early on that the past acts of discrimination, Jim Crow laws, slavery, segregation, would have a strong adverse impact on whatever we tried to do moving forward. And it was really from that perspective that the concept of affirmative action came into being. Specifically, Johnson recognized that a person who had been subject, in this particular instance, a race that had been subject to segregation, discrimination, Jim Crow laws, slavery, over an extended period of time, could not just by the snap of a finger or the blink of an eye erase the effects of that long storied history of keeping a race down and denying a race opportunities. And his position was that it would take something more. And that something more, in his opinion, was that it wouldn't be enough for the federal government to just sit back, that they would have to be proactive in terms of their response. And this is where the concept of affirmative action came into being. As it was set forth by Johnson in this executive order, the purpose was to remedy present effects of past discrimination. And the term affirmative action was used in the charge to federal agencies in terms of how they should proceed at the federal level to ensure that the benefits of the Civil Rights Act and the Voting Rights Act and other of the civil rights initiatives that were taking place at the time could be realized. From its inception, it has been controversial. From the day the executive order issued, it has been controversial. For many years, there was little or no action. Then there was a period of action, and then there was a period where there were a lot of court cases interpreting what was allowed and what was not allowed under affirmative action. What did affirmative action really mean? And finally, in response to certain court cases, there started a movement at the state level where citizens, through organized efforts, through grassroots efforts, different states came to it by different ways, took the position that if the state itself was not willing to do something to undo what they called preferences, commonly called affirmative action, then through the ballot initiative, they would take it upon themselves to change the law. And this is exactly what has happened. And the first state was California. And there's a lot of anecdotal information about California and its civil rights initiative. The initiative here in Michigan that's being proposed for the November ballot is really modeled on California. Some of the same people who led the initiative out in California have been involved here in the Michigan initiative. And so it's not on a truly blank slate that this is being written. We do have some history to look at in terms of the impact of these types of initiatives upon the civil rights laws and the abilities of minorities and women to enter places of higher education, government contracting, and employment. Today we have two very distinguished panelists who are going to help us, I hope, understand some of the nuances of what's going on in this ballot initiative. My hope is that not one way or the other you come out of here with a decision about how you're going to vote in November. That's really not my job. And my own personal preferences are really not the purpose for my being here today. But what I hope that we get out of it is a balanced approach to discussion of the issues, both pro and con. And I think that we all have to acknowledge and realize that there are good and bad points to either side. And what I hope these two gentlemen will be able to do for us today is to help us reach some informed decisions so that when we do go to the polls in November, that we will be able to make informed and reasoned decisions about how we want to vote on this particular issue. And also, in this particular setting, as a state university institution, junior college, this has a particular significance for Grand Rapids Community College, for Grand Valley State University, for Western Michigan, and all of the other state colleges and universities to which this initiative is directly addressing an issue. And that issue is, of course, admissions of minorities and women and others to the state's colleges and universities, and on what basis can that decision be made. And this particular initiative, falling on the heels of the Supreme Court's decisions regarding the University of Michigan's affirmative action policies, is particularly relevant and pertinent to the college students, professors, administrators, and all of you who have an interest in this particular topic. What I'd like to do now is introduce the panelists. To my immediate right is Professor Kalt. Professor Cald has his bachelor's degree from the University of Michigan and his Juris Doctorate from Yale. He teaches at the MSU College of Law, is that correct? And what is your topic that you teach?
Constitutional law, torts, and administrative law.
Constitutional law, torts, and administrative law. So he is well positioned to have an understanding of what the legal issues are, as well as a historical perspective in terms of how they play out. Sitting next to Professor Cald is Professor Fred L. Johnson III. Professor Johnson is an assistant professor of American history at Hope College in Holland. He has his bachelor's degree and teacher's certificate from Bowie State, his master's and doctorate degrees from Kent State, Ohio. His areas of specialization are U.S. military history, we could have a discussion on that, U.S. 20th century history, and Africa. And Dr. Johnston's particular interest, as well as his training, also make him well suited to address this issue, both from a education perspective, his impact on the education system, as well as from a historical perspective with his background in history. What I will now explain is just a little bit of the ground rules for how we hope to conduct this debate. First, each party will be given 3 to 5 minutes to make an opening statement, basically stating their position on the issue. Then I will have an opportunity to ask each of them questions for which they may respond. Some questions may be devoted to one individual, some to the others, and other questions will be devoted to both, and then they can each in turn provide a response. After that is completed, then the audience will have an opportunity to ask questions themselves, and I believe we have a mic so that can take place, and we will make sure that everyone, to the extent that we have time, can get an opportunity to ask their questions. In terms of the ground rules, I only have a few. First, listen respectfully, without interrupting, without arguing. Second, respect other points of view. Nobody here is here to force anything down anybody's throat, make anybody change their mind necessarily about anything, although you're certainly free to do that. But what we have to do, I believe, in order for this to be meaningful, is to proceed in a respectful manner. And I would ask that both of the panelists as well as of the audience. Criticize ideas, not individuals. This is not about people, it's about a concept. Avoid blame or speculation, if you can at all do that. I know sometimes it's hard not to do it, but we're going to try today. And finally, to avoid inflammatory language. So those are the loose rules. With that construct in mind, I am going to turn the floor over first to Professor Cald, followed by Professor Johnson.
Thank you. I wanted to note first on the sheet that you received that I don't actually have a PhD. Just want to make sure all the disclosure here is accurate. I haven't been a litigator for a while, but these things still jump out at me. I should also clarify, I am not here on behalf of the Michigan Civil Rights Initiative or any group associated with it. I'm not here to argue in favor of it. I'm certainly not speaking on behalf of Michigan State University or of MSU College of Law. I am here because I was asked, as someone involved in higher education who has some opinions that are sort of against affirmative action, but not necessarily about the MCRI, although I'm happy to answer questions and talk about them in general. What I'm going to try to talk about mainly is why I think that affirmative action in legal education is not a good idea. First of all, the numbers are very stark. In fall 2002, if you looked at the pool of applicants to law schools and you looked at the group that had grade point averages from undergraduate, their undergraduate GPAs of 3.5 or higher, and LSAT scores of 165 or higher. These were the people who, based on those numbers, would get into top 10 law schools. Of that group, there were about 4,500 of them. About 29 identified themselves as black, which comes out to less than 3 students per school. If we look at a 3.75 grade point average, a 170 LSAT, those are numbers that would give you about a 30% chance of getting into Yale. There were 336 white students with those numbers and 1 black student. Now, this is not a commentary on anything else other than what the numbers that we're dealing with are, but the fact of the matter is that if these top 10 law schools wanted to have more than 3 black students per school, they needed to admit people of color who had lower grade point averages, lower LSAT scores. The problem with doing that, among the problems with doing that, is that then the next 10 schools face a similar problem. The people who have grade point averages and LSAT scores that would ordinarily qualify them to get into the school, if those students are black, then they've gotten admission to the top 10 schools, and if the next 10 schools don't want to be devoid of black students, then they have to reach down and get students with lower grade point averages and lower LSAT scores. And this ratchet effect goes all the way down the line to don't use the U.S. News and World Report rankings, but it goes all the way down to the 4th tier. This would not be a problem if we weren't confident that grade point averages and LSAT scores were good predictors of success in law school, but they are. That's why law schools use them so heavily before they get to the race issue. That's why they use them so heavily to determine who to let in to the school. And you can argue about the LSAT score reflecting cultural bias, but of course if this is true, then students with a lower score because of cultural bias would do better in law school than their score would suggest, and there wouldn't be a problem, but there is a problem. A recent article in the Stanford Law Review went through the data of law schools nationwide and found that 92% of the black law students in the U.S. those years were in the bottom half of their class, and a majority of them, the median, was in the bottom 7%. Black law students are much more likely to drop out, to get low grades if they graduate, and to not make it through to the bar exam. Basically, the disparity is 83% of white students, 58% of black students. And what that suggests is that the LSAT scores and the grade point averages do a good job of predicting success. If you're in a top 10 school and you're competing against people who have higher scores than you, you're at a disadvantage. One might say that letting someone in a situation like that, despite the lower scores, is setting them up to fail. Now, that's not saying that everybody who's admitted with the lower LSAT, the lower GPA, is going to fail, or that all of them are being set up to fail. But it does suggest that attention to individual qualifications, finding potential for students, requires a little more subtlety than has been used. Once you're in law school, it's not just grades that are the basis for competition. There are things like law review, moot court, judicial clerkships, and these tend to go to the students who perform relatively well within the school. So you're better off, all other things being equal, at a school where you can get better grades. So looking at law school admissions, the way I view it as a law professor is we're saying we admit you to a law school, we're making a deal with you. We're basically a contract, if you will. I teach torts, not contracts. That's for a good reason, but I know this much. The deal is basically this. The law school says, you give us about $100,000, and we will give you the tools you need to become a lawyer. What they are actually delivering by admitting people on with credentials that put them at a disadvantage. Remember, the median in the bottom 7% is they're saying, well, we'll still take your $100,000, but in the name of leveling the playing field, we're going to give you a very unlevel playing field. Admitting someone with scores that far below the rest of the class is putting that person into an awkward position where they have to fight an uphill battle. That doesn't sound like a level playing field to me. Now, there are other elements of the argument that go more to affirmative action in general than to law school admissions in particular. My personal view is that it's a bit unseemly to generalize about people based on their race, and that's a problem under the law. If someone has experiences that indicate that they have more potential than their scores indicate, well, great. But if you're generalizing about them and saying, for appearance's sake, we will make these assumptions about you, that's not good. And I wrote something about this as an undergraduate about 12 years ago. I said, as soon as you've been classified in this way, you're not being treated equally. You're not being treated as a person. You're being treated as a statistic in a way that I think is not helpful. Now, one thing that we do with law school, at Michigan State anyway, and many other schools, is we have programs where we identify people who look like they have potential despite their grade point average, despite their LSAT score, and we give them a chance to prove themselves in a summer program. If they get through that, then they have a fast track to admission, and they have a head start since they've had a summer's worth of classes already, and then they go and compete on a much more favorable terms with their classmates. That's not a race-based program, although the demographics are helpful to achieving that sort of balance. But that's the sort of program that I think is helpful, treating people as individuals, giving them academic support, not just throwing them in to the pool and leaving them to fend for themselves with a tremendous disadvantage.
Your time is up. Professor Johnson.
Good afternoon, everyone. Thank you for having me here on this panel to speak on this. As Professor Simmons said, this very controversial, indeed emotional issue. And I would suggest to all of us that it is the emotion which has made it so difficult to talk about this. Because at heart, what we're talking about here are a variety of factors, all basically focusing upon access to resources. Resources in America that have always been in short supply, with more people trying to get to them than would be allowed to get to them or was available to them. And things like a college education or a job or housing or whatever it might be, all are determining factors and variables in just exactly if you get access and how much access you will get. Just as a corrective, please forgive me if I take a moment. I apologize to Professor Simmons. When I emailed my bio, it says assistant professor. That's an update that has to be made at Hope College. I was promoted to associate in January. I don't want the college to change its mind. And my primary field of specialty is the U.S. Civil War, primarily looking at the Confederacy. So the irony is that I am an African-American historian who, quite frankly, knows more about the Confederate flag than the people who fly it. Forgive me if I speak to you as an historian, but I will, since that is what I am. And I really have a hard time, quite frankly, whenever a situation like this comes up where I speak on affirmative action, because I have dealt with this subject, and I deal with this subject, first of all, as much as I can, as a disassociated individual or disassociated intellectual, trying to look at it dispassionately, trying to look at it objectively, as much as a human being can. But I also cannot help the fact that I have been in the midst of affirmative action, both as someone who it has been perceived as has been a beneficiary of it, someone who was perceived on some jobs I've had that I was there only because of it as opposed to qualifications, someone that's had to fight with, for, and against it. So I have been both a participant of the debate as well as a spectator and expositor of the debate. And I agree with Professor Call here and the opening statement. If we're going to actually have a talk about this, and I am an historian, so I am mostly, if you will, oriented toward the past. And I don't pretend to know what's going to happen in the future. My personal opinion is that affirmative action in its current state is going to change. And maybe it should. I come from the D.C. area. And quite frankly, there are neighborhoods in the D.C. area, African Americans in the D.C. area, particularly in Prince George's County. They live in these $1.2 million homes. They're doing very, very well. It's real hard for people who are on the opposition side of affirmative action to look at those individuals, their lifestyles, and have it logically compute as to why would they need a boost from the government or any kind of legislation. I understand that. What meets the eyes does not necessarily equate or compute into a reality that should be justified and protected when it comes to this debate. So I think it will change because of that kind of perspective. But on the other hand, it's not necessarily going to change because of that still very small number of African Americans or other minorities or women or even poor whites, quite frankly, who may need an assist of whatever type. But I think that the reason it's going to change is because of what I said initially, resources. But what I would hope we could do nationally and this afternoon in talking about affirmative action is to speak of it honestly. Because as I have observed this as both a contemporary participant and as an historian, it seems to me that the greatest, if you will, turning point upon which affirmative action usually gets screwed into the rhetoric is that it comes down to one group perceiving that another is getting advantage based on race. Okay? And my contention is this. If in fact, and this is the emotional side of the argument, if in fact all the emotional generation, all the rhetoric, all the reaching out for law to justify the emotional rhetoric is because we want to level the field, so to speak, so that one group is not advantaged over another on the basis of race, then we need to broaden this discussion and quickly. And in broadening that discussion, we need to own up to one fact. That fact is this, that in America, one group has always been advantaged over another on the basis of race. And it started in 1619, when one group, African Americans, were dropped at Jamestown, Virginia, and subjected to what eventually became legalized, institutionalized, constitutionally supported, sanctioned, supported, and maintained slavery that ended by law and then was reinstituted by law on a state-by-state basis called Jim Crow laws, where one group was advantaged over another for another 100 years on the basis of race. Now, I said to you before, I have been both a participant, target, if you will, lab study of all this. And the reason I say that is because I'm the first African-American history professor at Hope College. Hope has been around since the 1800s, the middle of the 19th century. Now, the good news is that it was done. The other thing that we have to connect with, though, is if we're talking about leveling playing fields, if we're talking about making sure that we're getting the most qualified candidates, if we're talking about all these kind of things that we want to happen all of a sudden right now, then we have to deal, I believe, with the historical legacy of the fact that there are generations of people who were probably geniuses and a whole range of other creative talents and abilities that didn't get the job, not because they didn't have the intellectual power, but because of how they came packaged. And I think that I could live with this a lot better at night if I could be suddenly assured, if any of us could be assured that if, let's say, for example, if this did go away, Is anybody prepared to walk out of here today and say that humanity is suddenly seen, or in this afternoon reached a point of enlightenment where organizations, institutions will suddenly do the right thing every time and take the most qualified candidate irrespective of who they are, where they come from, what gender they are? Because if that's the standard, taking the most qualified candidate irrespective of anything else, then let's go ahead with this. But if there's a possibility that may not happen, we have some talking to do. And we have some talking to do which focuses on how can we achieve that result with very imperfect human participants. Now, the reason why the executive order, I think that Dr. Simmons pointed out here, it was Executive Order 11246, where President Johnson used the phrase affirmative action, which required federal contractors to take affirmative action to ensure that applicants were employed. Folks, laws were passed that told institutions, you will do this, and left it up to them to do it voluntarily. They weren't doing it. They were dragging their feet, they were obfuscating, they were doing everything they could to get around doing this. And then the federal government came in again and said, you will do this. And finally, they broke it down by demographics. I saw it at my own company in Ohio, where if you have, for example, so many people, if a certain community was broken down by certain percentages, then that workforce had to reflect that. I know I'm out of time, so we can go ahead and get to the questions.
Thank you. And just because I know you were in the middle of a thought there, what I'd like for you to continue, if you will, for us, Dr. Johnson, is to talk about why we needed this federal order in the first place. What was it about the civil rights laws of the 1960s and the subsequent acts that made President Johnson feel it was necessary to issue this order in the first instance?
Do you mind if I go back to the end of the Civil War?
Yeah, I do.
Very briefly, the 14th Amendment, which was one of the Reconstruction Amendments, it was the Equal Protections Clause of the 14th Amendment, which Brown versus Board used to break down the walls of segregation in Brown versus Board 1954. And it was similarly that in 1964, when the Civil Rights Act was passed, that it was followed up by the 15th Amendment, the Voting Rights Act. Well, the Voting Rights Act was, if you will, a reiteration of the 15th Amendment, which pretty much gave African Americans coming out of slavery the right to vote. Now, unfortunately, the 14th and 15th Amendment excluded women. That, of course, was the flaw in both of them. But as far as African American men were concerned, at least, those were supposed to take care of it. Folk, 100 years later, we're still talking about this in 1965. So 100 years have passed when, frankly, in that 100-year period, in 1896, Plessy versus Ferguson, where basically, Plessy versus Ferguson was not necessarily a court case to determine if separate but equal would be legal, what should be established. It already was there de facto. All that court case did was weigh in on a social reality and determine that it could be legally maintained. Now, by the time you get to 1964, where you have the Civil Rights Act, like I said, the Voting Rights Act, like I said, there's still resistance. I mean, these are federal laws. Perhaps maybe I'm just naive. I think that when the federal government passes a law, you're supposed to obey it. Organizations were not. So by the time you get to 1972, you have the Equal Employment Opportunities Act, which was established to enforce the 1964 Civil Rights Act, and executive orders follow on that required the government contractors and educational institutions receiving federal funds to develop affirmative action plans. In other words, if you look at the historical behavior of institutions, and I mean academic, private, and otherwise, they dragged their feet every step of the way. They had to be dragged kicking and screaming into not giving a preference to somebody, but simply obeying the law. The law did not become as prescriptive in requiring quotas until organizations basically forced the government into making them have some type of a reflection of their communities or the workforce in those situations.
And I'm not asking you to respond to that particular point. I think that's a point that's been well made. But I would like for you, if you could, Professor Calt, to bring us forward to the present in terms of what is it, if anything, out there that gives you hope or makes you feel that in the absence of this forced affirmative action policy, that people are, in fact, going to somehow do the right thing?
Well, first of all, I can't disagree with anything that Professor Johnson said about the history, and I would just say that moving forward now, the issue has become sort of twofold. One, we saw in the University of Michigan case that the rationale that was given was no longer about redressing past discrimination, and that's not because there isn't still past discrimination that needs redressing. It's because the University of Michigan couldn't prove that. The 14th Amendment uses very neutral language. It doesn't say it's about helping one group or the other. It uses the same sort of neutral language as the Michigan Civil Rights Initiative, although obviously coming from a different direction. So Michigan needed a different justification for their affirmative action programs than redressing past discrimination. Their justification was the educational benefits of diversity. And that moved things in a very different direction.
With respect to the University of Michigan case, I would agree. But if I can get back to my original question for you, which is, what is it that you see, if anything, that gives you hope that somehow people are going to be rushing out to do the right thing if, in fact, affirmative action is abolished?
And I'm sorry. The first rule in law school is be sure you actually answer the question that you were asked, and I violated that rule. Well, I would say this: the laws that we're talking about here are not laws by which state agencies force private employers to do things. What we're talking about is what the state is doing for itself. Now, that's a big part of life, what the University of Michigan does or what Grand Rapids Community College does. But the first part of my answer to your question is we're already counting on it outside of the public context, outside of public education. We're relying on the laws that we have being advanced and enforced. What we're talking about here with the MCRI is not the private efforts, it's the public effort. So then the question becomes, well, what gives me hope that the government itself would do the right thing? And I guess that could go one of two ways. Either I could say I do trust that they want to do the right thing because, after all, they want these quotas, or if they're not quotas, then preferences, or if they're not preferences, then I don't want to get into a semantic battle. If they want these goals to be achieved and this one tool is taken away, I have no doubt that they will use that energy to find other ways, other channels to put that into. For instance, improving primary and secondary education and addressing the root of the problem. And I think that if there are people in government who want to get this result and this one way is taken away, they will find other ways within the law that would do that. The second point is that if you don't trust the law to be enforced correctly, and you keep adding more, it's like the barber who says, I don't understand. I keep cutting this guy's hair and it's still too short. If the law doesn't work, more law isn't going to work either. If social change is really what we need, then adding law upon law upon law isn't going to help. And I think moving the debate into something that would work instead of something that hasn't might be helpful.
Dr. Johnson, if in fact these reforms have been in place for decades, why isn't it that some other possible solution isn't preferred versus versus the use of preferences?
Well, I think that Professor Culp mentioned earlier about having a standard, whatever that standard might be, to judge individual performance. And I think that if I'm correct, I think that what part of the controversy, part of the indigestion with this whole debate is the fact that you have group preferences as opposed to focusing upon individuals, if you will, the standards of what we call the meritocracy. Well, I think that if there's any group, as a member of the African American community, if you will, locally and then at large nationally, as a member of the African American community, I can tell you that from the people, my friends, family, associates, acquaintances, and so forth, minority groups are most significantly concerned about making sure that they won't be perceived as having been allowed inside an organization because someone was given a nod to them, because they have to live with that legacy with their coworkers and so forth. So I don't know of any professional black person within my circle of acquaintance who is satisfied with being looked upon as if somehow or another they were given a handout and thought less than qualified. But on the other hand, there's the flip side of that, which is those who are qualified, and eminently so, still viewed the same way. Now, in that instance, it's not a question of one's qualifications. That's a question of the perception of those viewing them, which is not, quite frankly, a problem for the individual, but a problem for the individuals viewing them. So what kind of standard it would be, I think that given, if you will, the ethos of the United States, as it has said it wanted to be, where people move along and progress and advance or not advance based on their own individual skills, their own individual talents, gifts, and desires, that would be obviously the optimal one. That has not been the case, and it still is not the case today, because in too many instances, people who are not qualified across the board are moving ahead. And that is where I think, and again, I think that's where so many people have what sticks in so many people's craw when they see clearly that that is not the case, whether it be attributed to affirmative action or something else, and yet they're being told or they're having this other standard imposed upon them. Right there you have a situation of an uneven playing field.
Now, you raised some very interesting points, and I would like to follow up on a couple of them. Now, one of the things that has been talked about in recent, more of a focus in terms of the impact of the Civil Rights Initiative on groups is what impact this particular ballot initiative might have on women as a group. And if you could, Dr. Cald, if you could speak a little bit to that. I mean, you gave these examples about when you were talking in your opening statement about minorities, and I'm assuming you were talking about African Americans when you spoke, and how they had lower grade point averages and LSATs than whites, and therefore they shouldn't have been admitted to those schools. Was that your premise? Did I understand that?
Well, looking at the Stanford Law Review article, the point wasn't who should or shouldn't have been admitted. It's what happens to people once they're admitted, what kind of scores and grades are people coming in with, and then what happens to them once they're in law school, and the disparity is very stark.
You know, one of the questions that I'm not sure that I know the answer to, I don't know if you do or not, but could you tell me whether those people graduated from those law schools? Did you speak to the percentage of those that graduated? I think I missed that.
Yes, and I should say this particular article has generated some controversy for the conclusions that it spun out, but the underlying data have not been controversial, and the numbers overall were this: 83% of white students graduating and passing the bar versus 58% of black students graduating and passing the bar. And
is that on I'm just trying to understand what you're saying here. Is that on the first time? Is that ever? What do those numbers mean in terms of graduation and pass rate? Are you saying that only 58% of them graduated from law school?
That's basically saying for every 100 black law students that begin law school, 42 of them either don't graduate or don't pass the bar on the first try or subsequent tries. Ever. Well, I mean, you have to cut off the time at some point. Maybe some of them will go forward.
I'm just trying to understand the information that you're giving to us. So when you say that 58% of them, they either don't graduate or pass the bar, but you don't really know, based on this article that you're speaking to here, what percentage of them actually graduated from law school?
Well, I could dig through here and find the numbers. They're in here somewhere, but there is a tremendous disparity there too.
Okay, given that disparity, and then what I was asking, really, to move into the next question, is that there's been a lot of discussion and a lot of work out of the University of Michigan and elsewhere in terms of the impact of these types of ballot initiatives on women in the workforce, in education, and in government contracting. And I was wondering if you could speak to women as a group that had been historically disadvantaged, and whether the same arguments that you advanced in terms of minorities hold true for women as well.
On that, I can't base my response on the data in the Stanford Law Review article or any responses to it. I can speak from personal experience, both as a law student, as a law professor, and perusing some of the blogs and websites on this. My sense is that women are doing very well in law schools now. In a lot of places, there are more women in law schools than men, and you don't see the same sort of disparity where schools, in order to make sure that the class has quote unquote enough women in it, has to bring in women with lower scores and lower grades. So I don't think that issue is really there. There are a lot of other sorts of issues, though. The whole culture of law school, the whole culture of legal practice. I don't need to tell you about that. I'm sure you know it even better than I do. As a woman, you have a different experience coming into law school, and there are a lot of things that law schools probably could do and the legal profession could do to make that better. That said, we don't see the same sort of disparity in terms of numbers coming in and numbers coming out.
With respect to the law school faculty, do we still see disparities between the number of women and men as faculty in the top American law schools?
Yes. Yeah. There's law professors are disproportionately male. Now, as a function of what the pool is, I don't know. The two most underrepresented groups. There's actually James Lindgren at Northwestern University did a study. African American law professors are not underrepresented. The two most underrepresented groups on law faculties are conservatives and evangelical Christians, as the numbers spin out. So,
as a function of what? I mean, I'm not sure that I understand as conservatives or evangelical Christians as being any type of protected group here in the United States, at least not yet.
Obviously not on law faculties, at least.
Yes, but with respect to women, there still is the underrepresentation of women in the law school faculty.
There is an underrepresentation of women on law school faculties as compared to their percentage of the population and as a percentage of the legal profession. But the disparity in terms of how many women there are teaching law as a function of who's in the pool, that disparity, I would say, does not exist. That is, if you are a woman going into the legal academic market, your chances of getting a job, I would say, and I don't have data on this, hard data on this, but your chances of getting a job are as good or better than a male applicant with the same credentials. There just aren't as many women going out into legal teaching, and that's a problem that needs to be addressed. But those that do go out there don't have trouble getting jobs.
And with respect to the minorities that do go out there to get jobs teaching in law schools, is it the same issue?
Well, there not only is the difficulty in getting a job not there, but there isn't the same sort of underrepresentation either. That is, if you look at the percentage of the legal profession, and then you look at that is African American, and then you look at a percentage of law faculties that are African American, there's really not a disparity there, according to the Lindgren study.
Can you, if you're able to do so, can you sort of move that out of the law school arena into the general education population in terms of women and minorities as members of faculty of junior colleges, community colleges, colleges and universities? Do you have any information on that particular issue?
No, unfortunately, I don't.
Now, What about you, Dr. Johnson? Do you have some information about that?
No, I do not. The only information I have relative to that is a quote from a colleague of mine who said, "There's lies, damn lies, then there's statistics." And I think that one of the things that Professor Call brings up is another one of the complicating factors of this discussion, and that's not so much not only of the people who are currently represented on faculties or in student bodies right now, but the availability of candidates. And you can digress into a discussion as to how many are there, period, where are you looking when you go recruiting. If you're, for example, looking for an African American law professor, are you looking in northern Montana? Or are you going someplace where you're likely to find African American applicants? So this discussion is something that has an impact on admissions staff and admissions policies and exactly what you're doing. I talked to a gentleman in Indianapolis who, quite frankly, was just flabbergasted. He's been working for the last 10, 15 years with some of the most talented black students in the Indianapolis, Indiana area, and he routinely sends them off to schools that he has relationships with that are looking for just those kind of students, and they're there in abundance. But at the same time, he gets these calls from these other schools in the area that do all this crying about they can't find anybody, and then when he tells them what they are, they don't do anything. So there's a disconnect between what they're saying and then the follow-up and what they're doing.
You know, this all raises a very interesting question, and I don't want to minimize this issue of the Michigan Civil Rights Initiative because I think, honestly, that it goes far beyond mere affirmative action programs. And I wish that Ingrid could speak very Ingrid Scott Weekly, who's here, who is the director of the City of Grand Rapids EEO department. Could you stand up for a minute, Ingrid, please? And the reason I'm saying this is because we spend a lot of time and energy talking about affirmative action programs as that term, which for me is a term of art, when in fact in the 7 or 8 years that I was on the Civil Rights Commission, we approved exactly 3 affirmative action programs in that entire 7 or 8 year period. And Ingrid, who has sort of lived this issue for the past 15 years that I'm aware of, can speak very well to this particular point. The point being that most of the hiring and promotion and retention of minorities today really doesn't revolve around affirmative action programs. Am I right about that, Ingrid?
Right. In the City of Grand Rapids, for example, and for those of you who don't know, I work for the City of Grand Rapids, have worked for the city for just finished my 17th year, and I'm paid to administer the city's various affirmative action programs. And what we have found is that where we have had affirmative action goals, those goals have been for white women, and white women, by and large, have been the greatest beneficiaries of affirmative action. When we're talking about people of color, both male and female, the numbers simply don't justify us establishing affirmative action goals for those individuals. So what we rely on is diversity. We encourage, for example, department directors and those making hiring decisions to just really cast a very broad net in terms of their recruitment efforts. So you're exactly right, and particularly in the City of Grand Rapids, affirmative action in itself, where you're looking at underutilization and availability in establishing goals, has simply been a tool that's been used to increase the presence of white women in our workforce.
Now, my real question about this, and even though you might not have any particular knowledge about it, I would be interested in knowing where you're coming from on this. Given the fact that, and I would suggest, because I did in terms of my work on the Michigan Civil Rights Commission, I was privy to this. For instance, the fact that the state of Michigan does not have affirmative action programs, hasn't had affirmative action programs for many, many years. What they do have is an equal opportunity program. And I guess what's troubling to me is sort of throw the baby out with the bathwater sort of approach. And I'm wondering, as a lawyer and as a constitutional scholar, as you read this Michigan Civil Rights Initiative, whether you believe that other types of initiatives, such as diversity initiatives, would also be rendered illegal if, in fact, such a resolution were to pass, if that passed.
As I read the text of it, I don't think they would. Now, that's wishful thinking on my part, perhaps, someone might say, but unfortunately, the only way to find out is to pass it and then litigate the issue. Right? Someone will challenge an outreach program on the grounds that it conflicts with the MCRI. It'll go to court. The court will interpret the MCRI, and we'll find out. Finding out the hard way is probably not the best way to do it. But as I look at this, it talks about discriminating against or granting preferential treatment to individuals on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. To me, if that gets at outreach and support programs, that's a problem. But again, I think that there would still be legal avenues, that is, things that don't conflict with this if it passes, that would achieve much the same effect, like socioeconomic outreach that would have a lot of overlap with some of these same categories. In fact, getting rid of the admissions preferences we have now would probably increase that. All that energy going into those admissions preferences would go into more outreach, I would hope, and more support for people once they are in school.
One of the issues that has come up, and maybe you both can speak to this from an educational perspective, is what impact does laws, which by many are seen or perceived to be negative in terms of attacks on the ability of women and minorities to have equal opportunity. And I'm saying that because that is the tone of a lot of the literature that's out there, including, for instance, this particular handout. But one of the sort of the intended or unintended consequences, is hard to tell, is what message do the fact that Michigan as a state would adopt such a policy have on our ability to attract and to retain our women and minority candidates in schools and in government employment and those things? Have you thought any about that?
Well, I've given thought to it in other discussions that I've had. I think what was it, the last census, when Michigan was identified as being one of the most segregated states in the Union. And so that, followed by an initiative like this, hand in hand, and again, perceptions, people's realities are their perceptions. For people who might relocate here, people who might come here, it's a very basic human question. Why bother if opportunity exists someplace else? And in this day and time where, to borrow the title of Thomas Friedman's book, if the world is flat, and we're talking about a global economy, and we're talking about trying to harness skills, talents, and resources so that this nation, this state as part of this nation, can be as strong as it can be, irrespective of where the productivity comes from and how it comes packaged, then we need to, I think, be discussing what can we do to attract people with those talents and those abilities here. And if they don't necessarily see that they're going to, if they necessarily see they're going to come someplace and be faced with a whole bunch of societal issues in addition to the usual things that one might find on the job, I don't know. They may weigh in and say, I'll just go elsewhere. Now, if the state doesn't mind that, if employers don't mind that, well, I guess that we'll just see.
Well, at the risk of getting back into statistics, I would be interested to see what the effect has been in California and Washington. I mean, I don't know, but my own perception is that California is doing okay. People still go to California. People still go to Washington. There are people who aren't happy with these initiatives, maybe who would have gone there and didn't. But we need better information on that than just my own perception of it or someone else's perception of it. I would be interested to see whether that really factors into someone's decision making or not. I don't know.
Well,
I can assure you that it does. I've talked to people, and again, not to stray back into statistics. I don't have any kind of statistical information backing this up, but I have talked to people who have made the decision based on the very question you asked. They have put 1 and 1 together, 2 and 2 together equal 4, and they've gone elsewhere. So it does have an impact.
I actually have read some things on that, and I do believe that there is some statistical information available out of California on that particular issue, but I would submit that it is a question that we need to consider.